going to be a...
1 second.
Okay.
1 second. I just have to get this started.
Hey, Eric, Jessica's muted.
Sorry, while we fix the technical piece.
Okay, we're good.
All right, great. Well, for those of you who haven't heard me yet, I'm simply welcoming you to opening up our Law Review Symposium and noting that the symposium is focused on recognizing the 25th anniversary of the passage of two significant federal statutes. The first, the Anti-Terrorism and Effective Death Penalty Act, sought to recalibrate the relationship between state and federal courts by limiting the scope of federal habeas corpus review of state criminal convictions and by restricting the availability of federal habeas relief. The second one is the Prison Litigation Reform Act, which limited the availability of federal relief for prisoners by codifying exhaustion remedy requirements, mandating full payment for filing fees, requiring a physical injury as the basis for recovery for mental or emotional injury, and adding a 3 strikes rule that bars prisoner access to federal court in certain circumstances. Among the issues this program will explore are the statute's impact on persons and communities of color, the ability of prisoners to obtain meaningful judicial relief, the health consequences for prisoners during the COVID-19 pandemic, the ability of the federal courts to address prisoner claims, and the relationship between state and federal courts. The symposium is co-sponsored by the Federal Litigation section of the Federal Bar Association and the Northern District of Ohio chapter of the FBA. The Attorney Admissions Fund of the United States District Court for the Northern District of Ohio has also provided financial support. This promises to be an incredible program, a number of really impressive speakers. And I'd like to actually briefly turn it over to Andrew Rumschlag, the editor-in-chief of our volume 72 of our Case Western Reserve Law Review, who will go over the day's schedule. Thank you.
Thank you, Dean Berg. Thank you all for coming today. I also want to thank all of our symposium moderators and speakers for making time for this program today. Really excited about it. I'd also like to thank a few people who are absolutely instrumental in making this program happen today. Mr. David Saylor, who handled all of our logistics for the in-person program. Martin Raska and his team for dealing with the technology aspects of this so that we can offer this hybrid format. I also want to thank all of our associate editor volunteers who are helping out today as well. Professors Adler, Benza, Hardaway, and Hill all helped us in our early planning and reaching out to speakers early on. And of course, Professor Enton, our law review faculty advisor, has been a constant source of guidance and help with finding funding, finding speakers. So thank you, Professor Enton. And ultimately, this is the brainchild of Reagan Joy, who is back there. Reagan, thank you very much for all the hard work that you have put into this and making this happen. So today's schedule includes 4 panels. The first will begin here after I finish speaking, and Professor Hardaway will lead a panel discussing the pandemic's impact on prison litigation. Then we'll have a brief break followed by a panel at 10:30, where Professor Benza will discuss litigators' perspectives on these statutes with practitioners. Then from 1:15 to 2:45, after we have a break for lunch, we will have a panel on how we will reform these statutes. We could reform these statutes led by Dean Adamson. And then we'll have another brief break followed by Professor Enton leading a panel in which we will get federal judges' perspectives on these statutes. Without further ado, I'd like to turn it over to Professor Hardaway for the first panel.
Good morning. This is going to test my eyesight. I have to look at the back of the room to see you guys appearing virtually. My name is Ayesha Hardaway, and it's my pleasure to introduce our first set of panelists. We have first Hadar Aviram, professor at the University of California, Hastings College of Law, specializes in criminal justice, civil rights, and politics and social movements. Her books include Cheap on Crime, Recession-Era Politics, and the Transformation of American Punishment, and Yesterday's Monsters, the Manson family cases and the illusion of parole. Professor Aviram has published articles in leading journals on domestic violence, prosecutorial and defense behavior, public trust in the police, correctional policy and budgeting, violence reduction, theoretical trends in crime and punishment, and the history of female crime and punishment. She served as the president of the Western Society of Criminology and is currently the book review editor of the Law and Society Review. Her blog, California Correctional Crisis, covers criminal justice policy in California. Welcome, Professor Aviram. Our next speaker or presenter will be Nancy J. King, the Lee S. and Charles A. Spear Professor of Law at Vanderbilt University. Professor King is an expert in criminal procedure. Her work focuses on post-investigative features of the criminal process, including plea bargaining, trials, juries, sentencing, appeals, double jeopardy, and post-conviction review. She is co-author of 2 leading multi-volume treatises on criminal procedure and of the leading criminal procedure casebook and several books, including Habeas for the 21st Century, Uses, Abuses, and the Future of the Great Writ. Professor King has also published dozens of articles in leading law reviews and is associate reporter for the advisory committee of the Federal Rules of Criminal Procedure. Professor King clerked for Judge Douglas W. Hillman of the United States District Court of the Western District of Michigan and Justice Michael F. Kavanaugh of the Supreme Court of Michigan. And then last but not least, we have Margo Schlanger, the Wade H. and Doris M. McCree Collegiate Professor of Law at the University of Michigan. Professor Schlanger is a leading authority on civil rights issues and civil and criminal detention. She previously taught at Washington University in St. Louis and Harvard Law School, and she served as the Officer for Civil Rights and Civil Liberties and as counsel to the Secretary of Homeland Security. In addition, she was the reporter for the American Bar Association's revision of its standards on the treatment of prisoners. She is the author of dozens of articles in leading law reviews and is the lead author of a leading casebook, Incarceration and the Law. Professor Schlanger also does substantial work in civil rights litigation and prison and immigrant reform. She has been appointed as class counsel in a class action that seeks to ensure due process for Iraqi nationals who are facing deportation, and as moderator for a statewide settlement dealing with death prisoners in Kentucky. And she has testified as an expert in numerous cases addressing detention conditions, She was a law clerk to Justice Ruth Bader Ginsburg of the Supreme Court of the United States. Welcome to our panelists. It's my understanding that your preference for presenting this morning will be in the order of Professor King, Professor Schlanger, and then last but not least, Professor Aviram. Is that right? I saw a thumbs up. Very great. Thank you. Professor King, it's all yours.
Thank you. Thank you very much. Can you hear me all right?
Yep, I hear you fine.
Okay. Yeah, I've discovered that this morning when I arrived, they have started construction outside my window. So if you have any trouble hearing me, just put your hand up to your ear or interrupt me, and I'm happy to try to do something else. I'd like to thank you for inviting me to the symposium. This is pretty exciting on 20 years of AEDPA and PLRA. I thought I'd just offer two modest observations about COVID and habeas for us to think about today. Both points concern not so much what AEDPA did, but more what it didn't do. In particular, the restrictions that Congress imposed on the habeas remedy in the Anti-Terrorism and Effective Death Penalty Act, which people refer to as AEDPA. Some people call it AEDPA, but I think it's probably AEDPA and more for more. It greatly limited, put severe procedural restrictions that hadn't been already there on the habeas remedy. But what it didn't do is it did not eliminate the equitable powers of federal courts in applying the statutory remedy. And it didn't touch 2241. And those two things played a role in habeas litigation during the pandemic and still are. And I wanted to focus on them and put those in perspective. So let's start with the first point here about the equitable powers of federal courts in applying the statute. One of the most restrictive and impactful limits of AEDPA was the statute of limitations, replacing the doctrine of latches as the method of determining when a petition filed by either a state or federal prisoner was too late. And a study from petitions filed in 2004 and 2005 by state prisoners found that the statute of limitations was the reason for dismissal in an estimated 22% of state non-capital prisoner filings. So it really made a big difference. But despite this restriction, the court, since AEDPA was passed, has repeatedly enforced the equitable leeway or flexibility of courts in applying the statute of limitations. So for example, in 2010, they recognized equitable tolling so that a petitioner's late filing would be excused if the petitioner could show an extraordinary circumstance beyond his or her control and diligently pursued filing rights as well. So not surprisingly, starting in March of 2020, when we were all locked in, the courts started being asked and granting tolling for conditions that restricted the ability to file on time. For example, courts allowed tolling for conditions that prevented in-person competency evaluations, prevented an inmate from accessing the law library or documents needed to create the petition, prevented an attorney from meeting with the petitioner, or resulted in closing the courthouse. So these equitable considerations made a difference in the application of AEDPA. Now, the second point I wanted to make was that the AEDPA statute left intact 2241, which was the original habeas remedy left over after Congress modified it in the 40s to allow to regulate attacks on custody resulting from state criminal judgments and federal criminal judgments by creating 2254 and 2255. What was left over was 2241, which simply said a district court may grant a writ of habeas corpus if a prisoner in custody of a violation of the Constitution or laws of the treaties of the United States. So for a very long time, this 2241 language, the original habeas corpus remedy, has enabled judicial review during times of crisis, periods of turmoil, when judicial review is needed, but it isn't already supplied by another statutory scheme. And so, in other words, it served as sort of a backstop. When other remedies don't work, try 2241. So you can see this pattern playing out over time with the constitutionality of pretrial detention, immigration detention, military detention, civil commitment, all of which eventually developed other statutory schemes more tailored to those concerns and funneling those claims outside of 2241. But everything that's left over that doesn't fit, 2241 is there for petitioners to try. And I was wondering if that might have occurred during COVID as well. And that's what I was looking at cases. What my short essay for the symposium will be about is how 2241 was interpreted by federal courts in the context of pandemic-related claims. Now, among the claims that courts are used to analyzing under 2241 are administration of sentence claims, they're often called it, where petitioners and applicants under 2255 as well come to the federal court saying, I should be released earlier, or my good time credit was calculated incorrectly, something to do with the revocation of release was screwed up, not attacking the underlying criminal judgment at all, only the administration of the sentence that resulted from it. And this is different than the statutory remedies that probably Professor Schlanger will be talking about, although I don't know, but she is the nation's expert on these things. So I'm guessing that she will be talking about conditions of confinement claims, which are civil rights claims filed under yet another statute, 1983 for state prisoners, or Bivens actions for federal prisoners. And these administration of sentence claims that I was talking about before are different than those. They're not claiming that the conditions of confinement are unconstitutional or violate the Eighth Amendment. Instead, they're saying this, I need to get out of release. I should be released immediately for these following reasons, unrelated to the conditions, not necessarily related. I'm not asking for better conditions. So this turned out to play a role and is playing a role in some courts during the pandemic. Most courts, when petitioners brought pandemic-related claims seeking release, characterized them as conditions of confinement claims. They said, look, what you're complaining about is that it's too dangerous for you to stay there, and something has to be done to make it less dangerous. So you should have brought this under Section 1983 or as a civil rights claim and not as a habeas claim for release. But other courts, including the Sixth Circuit and many district courts, read the Supreme Court's precedent establishing the line between conditions of confinement claims and habeas claims as allowing these to go forward under 2241. So for example, the Supreme Court in a case called Prizer versus Rodriguez held that a challenge to the constitutionality of disciplinary proceedings that led to a deprivation of good time credits, and the petitioner was seeking earlier release. The court concluded that a state prisoner can't use Section 1983 to attack that sort of claim, but instead that falls within the core of habeas corpus. Pointing to this language and some other decisions of the court, which I'm not going to go into given our time constraints here, the Sixth Circuit decided in a case called Wilson versus Williams that petitioners who were seeking immediate release from confinement during the pandemic because of their medically vulnerable status could bring a 2241 claim, that it was cognizable. And several district courts also followed this. Now, the Sixth Circuit case ultimately did not succeed for another reason. But some of these other courts recognizing 2241 jurisdiction over these claims for immediate release did go forward and resulted in release and ultimately settlements that are now playing out in a number of jurisdictions. I can go into those in more detail at the Q&A, but just to bring you back to the debate about this line between Section 1983 cases and habeas cases and which statute applies, most courts, again, found that these claims were conditions of confinement claims. And they were worried that, that it would be too easy. For example, one court wrote, the risk of turning 2241 into a general civil rights statute by the mere expedient of a petitioner seeking that release remedy is high in every habeas action in which conditions of confinement are at issue. So what differentiates this action in habeas corpus from a garden variety civil rights action was the response of most courts. But nevertheless, there was this flexibility in 2241, this uncertainty that allowed at least some courts to use that statute to address what was a novel claim, just like they had been over many, many decades when confronted with other sorts of novel claims about detention. So just to sum up my, again, what I admit are modest observations about what's going on with habeas and COVID claims. This wiggle room for federal courts, even despite the AEDPA's restrictions and in equitable tolling and other equitable rulings, continues to be vital for Congress to preserve, for courts to preserve, although it is a two-edged sword, right? You can use equity both to expand or permit relief, but the court has used equitable considerations to restrict habeas as well. And so preserving that equitable discretion is not a one-way street here. It could go either way, but it is important for the court to be able to tailor it to the new and unexpected circumstances that confront courts under and those who are confined by the government. As far as 2241 goes, I think it's really important for the Supreme Court to preserve its complete common law flexibility to address completely unexpected situations that we may confront in the future. This one may not be long lasting. We don't know. And I don't think I agree with Leo Kowarski and others who his excellent collection of litigation under the during the pandemic and showing all the deficiencies in the various remedies that have failed prisoners during this time. I do recommend that. I'm not trying to canvass all of the other remedies, but that 2241 statute is essential. And I think stepping back and looking at how courts dealt with these claims during this particular crisis is somewhat consistent with the way that they have dealt with claims in the past when confronted with some new crisis in confinement. And that's all I wanted to present for you. I'm happy to take questions as we go on. Thank you.
Thank you. We're going to do the questions at the end. Is that right? Law review? Awesome. Okay, great. Next, we'll have then Professor Schlanger.
Great, thank you so much. It's really nice to be with you all virtually. I'm sorry that I couldn't attend in person and to participate in this somewhat depressing topic of 25 years of the PLRA and AEDPA. I didn't realize when I started working on PLRA issues as a lawyer at the Justice Department the year the statute was passed that it would have such a role in my career for basically ever. So what's been going on for 25 years is that the Prison Litigation Reform Act has undermined the constitutional rights of incarcerated people. That's, in fact, part of what it's aimed to do. Its aim is to make it harder for people to file and win constitutional cases that involve their confinement, their incarceration. So it's succeeded at that. And we've seen the result in the pandemic. The wave of litigation that has occurred related to COVID-19 by prisoners is kind of only to be expected. Incarcerated people tend to be quite medically vulnerable. The prevalence of chronic disease and disability is very, very high behind bars. And so they are at risk. And equally important, they lack most of the methods that the non-imprisoned have to minimize their own risk. Prisoners can't avoid communal spaces for eating, living, bathing. The availability of personal protective equipment is subject to the constraints placed on them and sometimes the whim of the authorities who incarcerate them. They can't pick with whom to associate, whether to limit their association with people who are unvaccinated, unmasked, uncareful. Staff contact in particular is mandatory, but this is true with prisoner to prisoner contact too. And the result of this, as one would expect, is that there's an infection rate among people behind bars of about 5 times in the general population is misleading, in the unimprisoned population. And the mortality rate, after controlling for the fact that these are generally speaking young men, is about 3 times the rate not behind bars. So the result of all of that, which of what is a very high level of risk, I want to be clear, not the same level of risk as in nursing homes, right? That's much higher. That's for a variety of reasons, but still a very high level of risk. The result is that people brought lawsuits seeking changes to policies and practices. They asked for better sanitation. They asked for social distancing. They asked for an enforceable right to have staff use masks. They asked for vaccination. They asked for release, as Professor King was just talking about. And the PLRA has stood in the way of every one of those claims. Now, sometimes people have gotten past it, but it has posed a hurdle for every one of those claims. So let me share a slide. I hope you all don't mind. Oops, slide here. So the PLRA has, just if you want to think about it overall, wait, really? Hang on. There we go. This is a chart that almost every article I've ever written about the PLRA has had in it. So let me just share it with you. This shows prison and jail population. Those are the bars over time. So you can see you can see the massive run up in mass incarceration starting in 1970, going to about 2010, at which point there's been a modest decline in incarcerated populations. And then in the blue bar, you can see filings classified as prisoners' rights filings in the federal court system. So not habeas, conditions of confinement filings. There's some misclassification. This number isn't perfect, but it's the best quantitative data we have. That's the blue line. And then the red line shows the rate of filings. Because as prison population goes up, of course, you'd expect prison filings to go up, but in fact, the rate has sometimes gone down. Okay, so what do these two lines show us? They show that there was this huge run up, not only in prison population, but in prison litigation from the 70s to 1995. Now, the run up was actually not nearly as much as you might have thought, because you can see that red line from 1980 to 1990, showing that the rate actually decreased very significantly in that decade, and then crept back up again in the first 5 years of the 90s. But the result is that prison litigation was it was pretty pressing from the perspective of prison and jail authorities in 1995, which is why the PLRA got passed. The PLRA had this instant, very significant dampening effect, driving the numbers back down to what they'd been in 1990, and driving the rate back down to what it had been in the early to mid 70s, and eventually really to the early 70s, where it has stayed ever since. All right, so that's the basic story of the PLRA. And the provisions that have done that are the ones that were identified to you at the beginning of this, before this panel started: the filing fee, and the limits on the availability of relief for emotional and mental injury, the limits on attorney's fees, and so on. There's a whole variety of provisions. The one I'm going to talk about is exhaustion. Here's the PLRA's exhaustion provision, which I think has been the most pernicious, actually, of the provisions in the PLRA. It says, no action shall be brought with respect to prison conditions under Section 1983 of this title or any other federal law by a prisoner confined in any jail, prison, or any correctional facility until such administrative remedies as are available are exhausted. Forgive me for reading to you what you can also see, but it's important enough that I wanted just to dwell on this for a minute. Okay, so what has that meant? So in what I believe total 6 Supreme Court cases, which is a big number for one provision of a statute, right? 6 provisions. I worked some on an amicus brief that got filed a couple of weeks ago in an exhaustion case. And the lawyer said, well, we really feel like we have to explain to the justices exactly what exhaustion means. And I was like, no, it's new to you because you're a law firm lawyer. This is their 7th case on this topic. In any event, what has it meant? Exhaustion is an affirmative defense. Prisoners are not supposed to have to plead it. They're not supposed to have to prove it. It's up to the prison to demonstrate that there has been no exhaustion. Courts mostly, well, many courts don't understand this first bullet, but that is the rule. That is the clear rule. There are no federally prescribed standards requiring fair grievance systems. There used to be. Before the PLRA, there actually was such a set of standards that said if you want to have an exhaustion requirement, prisons and jails, here's what your administrative system, your grievance system has to look like. The PLRA undid that. There are no federally prescribed standards. The PLRA requires proper exhaustion enforced by a procedural bar. It's not simply a ripeness rule, it's a procedural bar. In other words, if you mess it up as a prisoner, you're out. Not only have you undermined your possibility of your grievance succeeding, you've actually done away, what has happened is that no longer do you have a right of access to the federal court either. None of the traditional exemptions from administrative exhaustion requirements, the primary one that matters for us being futility, apply. In other words, it doesn't matter if the system, suppose all you want is damages and the system cannot award damages, the grievance system, doesn't matter. As long as the system is capable of handing you any remedy at all, you must go through it as a prisoner. There is no excuse for good cause. There is no excuse for special circumstances. But the statute requires, I'll go back to it, only exhaustion of such administrative remedies as are available. That's under Ross versus Blake. And that is the crucial provision for our purposes. Okay, so, whoops, sorry. So what does this mean? Well, we have a set of both ordinary problems. The exhaustion, the requirement of proper exhaustion incentivizes complications and procedural traps. In other words, the more complex you can make your system as a prison official, the more likely you are for people to mess it up, and then your prison is immunized in conditions of confinement cases. I don't mean that prisons always exercise this kind of bad faith, but it's certainly the case that the incentive is for them to add layers, add complications, make it hard to exhaust, because if a prisoner neglects to dot I's and cross T's, and some of the cases you wouldn't believe, you know, files with red ink is one that's kind of famous, but true. I found it. I mean, I'm not the only one who found it, but some people doubted it existed, and I went and spent some time and ran it to ground. Or the system says you have to file on one page, but you had trouble explaining all the facts on one page, so you filed on 2 pages, you're out. The system says you have to tell all the relevant facts, but you stuck to 1 page, you're out, and so on. Okay, so that's one set of problems. A second set of problems is that grievance systems are slow and cumbersome, and emergency speed-ups often fail. Okay, those are kind of the normal issues. I could come up with others, but emergencies create the 4 additional system stressors that I have on this slide. They pose new risks, they increase the importance of speed, they undermine normal institutional coping. You know, because of COVID, for example, lots of staff were gone, right? And that means that the institution is short-staffed for all kinds of purposes, which both generates the problems that people want to grieve and also undermines ability to process grievances, right? So these are emergency situations. So what to do? Well, I think, and I actually didn't notice when I started, so I'm not sure how much time I have left. But I think that there are 3 potential solutions. And when I have written this up so thank you to the Law Review for offering a forum to put this stuff into. The 3 solutions that I propose are, one has to do with unavailability doctrine, one has to do, and that's a judicial one has to do with the people who run prisons and jails, how they could actually implement working emergency grievance systems, and one has to do with the Congress, which could amend the Prison Litigation Reform Act. So to run through that fairly quickly, under Ross versus Blake, an administrative procedure counts as unavailable if it is a simple dead end. Not if it offers you relief you don't want. That's not unavailable, right? Like it offers you a change going forward and you want damages, or it offers you damages and you want a change going forward. Either way, that's not unavailable. But if there is no relief that if it consistently denies all relief, then that counts as unavailable. So that means, for example, if the prison is locked down and you can't get access to a grievance form, or you have your grievance form, but there's nobody to give it to because nobody ever talks to you, or the grievance officer, who's the only one who can accept the forms, is out for the entire pendency of the period of time where you could file a grievance, or whatever, right? If the system is unavailable for those reasons, actually the cases have been fairly consistent that under Ross versus Blake, you don't have to have grieved. You can't do the impossible. But what if there's a different kind of claim? What if a prisoner says, look, I have asthma and a history of pneumonia, and I'm really at risk from COVID, but there's no social distancing here. They haven't let me have a vaccine yet. This is no longer mostly the case, but it used to be, right? Nobody's let me have a vaccine. The staff aren't masking up. There's no social distancing, and I'm going to get it. Like the prevalence rate in this prison is sky high and getting higher. I'm going to get COVID. I'm going to get very sick. I could die. And the grievance system requires 3 layers of review, each one of which takes 60 days to get through. So I'm 180 days out, even if everything goes exactly the way it should, before they have to answer me. And I need relief next week. Okay, so that's the question is that unavailable? Does that mean that the grievance system is unavailable? And here we have a circuit split with the 7th Circuit saying, yep, not in a COVID case, but in a pre-COVID case. The 7th Circuit says, yep, that's unavailable. And our home circuit, the 6th Circuit, saying, I'm sorry, are you kidding me? That's not unavailable. That's whining. And so those are, and the district court cases are all over the map, although I haven't done anything very systematic to see which, I'm sure there are more saying, no excuse for you, but there are quite a few saying, yep, that's unavailable. So, so one solution to this emergency problem is to take seriously what Ross versus Blake says. If officers are unable to provide any relief, and the only relief that matters is relief in the next 5 days, 10 days, 15 days, and they're unable to work a grievance system in a way that can answer that, that's unavailable. And the prison system then has 2 options. It can allow those lawsuits to go forward, right? Judges can accept those lawsuits, or the prison system can build solution 2, a functional emergency system, which includes urgent matters, which has really speedy processing when the grievance calls for it, and which has simple enough procedures that they can actually be followed during an emergency. So Delaware, for example, has an emergency process that covers an issue that considers matter. Somebody ought to do some edits, but whatever. An issue that considers matter which under regular time limits would subject the inmate to a substantial risk of personal, physical, or psychological harm. So that's a pretty broad inclusion. And there are systems that promise, I don't know that they actually succeed, but that promise very speedy processing in sufficiently important time-sensitive matters. So I think this is a doable solution, and that prisons could do it. If they don't, I think the rule of Ross versus Blake is clear, that exhaustion is only required when the grievance system is available, and it's not available if it can't possibly give you anything that matters. Okay, so I want to admit, though, this is it's not a no-brainer interpretation of Ross versus Blake, right? But I think it's the correct one. A third thing is that Congress could amend the PLRA, something along, oh, look, I have an extra paren, something along the lines of this proposed statutory amendment that says, look, during an emergency, which would need to be defined, I could give you a definition, but it would need to be defined, prisoners need not exhaust. And that would be very clear. There are folks on the Hill considering such an amendment. It's been put into, it's gone through legislative council and so on, but no one has introduced it yet. So there is a draft bill floating around that I think the odds of it going anyplace are pretty low, but you never know. And it seemed worthwhile to say, well, what would that really look like? So I think I'm probably out of time, but so I'm going to stop. But those are some solutions to what I really do think is a pretty appalling problem. Prisoners have been told that they cannot get into court, which I take as one of the core commitments of the system of enforcing the Constitution. Prisoners have been told that they cannot get into court unless they use systems that in point of fact are unable and unwilling to either provide them a path to a remedy or even a path to a decision on their requests. And I think that's outrageous and should be changed. All right, I'll stop. Thank you.
Thank you. I'm sure we'll have some good questions about those solutions. But first, we need to hear from our final panelist, Professor Aviram.
Thank you very much. Thank you for inviting me to the journal, and many, many thanks for allowing me to do it from home, which has solved serious logistical issues in my family. It's delightful to be here, and it's great to be here with Margo and Nancy, whose work I admire greatly. And the comments I'm going to make build a lot on the legal scaffolding that they made. Although admittedly, I'm a social scientist and I tend to look more at how things play out in the political arena in practice. And because of that, I'm going to talk about a very concrete situation. So I will share my screen with you. So the comments I'm going to make today are going to eventually be chapter 6 of my book in progress, Fester, which is about the COVID-19 crisis in California prisons. And today I'm going to focus on the limits of litigation, both at the state and at the federal levels. And I want to start with an article that I believe both Nancy and Margo mentioned by our colleagues, Brandon Garrett and Lee Kowarski, called Viral Injustice. So they've read hundreds of COVID-19 custody cases, and here are the conclusions that they've reached. Our analysis defines the decision-making by reference to 3 attributes: the substantive right asserted, the form of detention at issue, and the remedy sought. Several patterns emerged. Judges avoided constitutional holdings whenever they could, rejected requests for ongoing supervision, and resisted collective discharge, limiting such relief to vulnerable subpopulations. The most successful litigants were detainees in custody pending immigration proceedings, and the least successful were those convicted of crimes. So this in itself is distressing, but the question is, why and how is this happening on the ground? The main argument I'm going to make is that, at least in the context of California's COVID-19 prison litigation, which I'm deeply familiar with, following it up not just for the book, but also as part of the legal team, is that the PLRA is just a scaffold. Of course, it's not a factor in the state cases. And what can explain what's going on here is a lot more deep-seated political animosity toward actually reaching a hand and helping people in these circumstances. And I will take you step by step through this litigation to show you how this happened and how it played out in California. Now, I should say, shockingly, I came across this report from Prison Policy Initiative that shows that California is actually one of the better state prison systems during COVID-19. They have this scorecard that they've given the states. You can see yourselves right here. So more things to be proud of today. And also amazingly, they come to the conclusion that California is one of the states that made the more significant efforts to reduce prison population. I will tell you that the prison population in California is up by several thousand people from the beginning of the pandemic. So I don't know how they came to this, but if California is one of their top states, I don't know what's going on with the other places. So this is the picture as of this morning. I took this shot just 15 minutes before the panel started. This is from the ticker on the CDCR website, California Department of Corrections and Rehabilitation. You can see that more than half of our prisoners, 51,000 people, got the disease. And we've had 242 deaths that I'm going to argue were completely preventable. Prisons in California, like every prison, and this is something that Margo mentioned earlier, are susceptible to contagion and disease. This is just in the last couple of decades, we've been battling an infection of valley fever in our prisons, and many people suffer from long-term effects of that. And this is just one of many examples. The inability of the California medical system in prisons to provide people basic constitutional care led to very lengthy litigation in a case called Brown versus Plata, which eventually came to the Supreme Court. In the aftermath of Plata, after many, many years of making efforts to reform the prison system, after basically taking the medical system out of the hands of the state and giving it to a federal receiver in 2006, eventually the case came to a 3-judge panel. And overcoming the many hurdles of the PLRA, the panel ordered that the population in the prisons, which were at the time crowded to 200% capacity, be reduced to 137.5. And this is the effect of that. In the aftermath, the case came all the way to the Supreme Court. Then Attorney General, later Governor Jerry Brown, fought it all the way to the Supreme Court. But at the same time, they realized it was going to be inevitable. And in 2011, they introduced a legislation called the Public Safety Realignment, which led to the reclassification of where people actually do their sentences. It basically consisted of a jurisdictional shift of pushing people out of state prisons and into county jails. And that was somewhat of a bump, although it didn't get them to where they needed to be to comply with the litigation. And then a few years later, in 2014, voters passed Proposition 47, which reclassified some less serious crimes as misdemeanors, leading again to a chunk of people either not being incarcerated at all or being incarcerated in jails instead of prisons. And that finally brought them into compliance with the threshold established in Plata. So the system was finally Plata compliant, but of course it was still overcrowded. It was still at 137.5%, which is a lot more people than you can manage in a situation like a pandemic. Moreover, the mandate in Brown versus Plata was a system-wide mandate. So the whole system had to comply with this number, but they didn't say that every individual prison had to do it. So coming into March 2020, several prisons, about a third of them, were at 150% capacity, so still grossly overcrowded. And of course, because the jails were to be the release valve for the state prison system, that meant that the jails became overcrowded and sprouted a lot of healthcare problems of their own. So coming into March 2020, several people, including people on this panel, published op-eds and argued very, very vocally that this is going to be a real test for the prisons and that we must decarcerate now to allow us to handle this pandemic. This was crystal clear to people back in January and February, and it was also crystal clear to county officials in the counties neighboring those prisons back in March. And they talked to the prisons and tried to alert them to what was going on. The prison didn't listen, and several disasters ensued. So prisons started seeing a rise in cases in March, but some prisons like St. Quentin managed to be fairly COVID-free until late May. And then, because there was an outbreak at a prison in Chino, they took prisoners from Chino, about 200 of them, and moved them around to St. Quentin and Corcoran. They packed them on buses like sardines, one next to the other. And before they boarded the bus, several prisoners who had not been tested for COVID for weeks came over to the nurses and said, "We're coughing, we have a fever." And the nurses said, "Shut up and get on the bus." As a consequence, they were being brought into St. Quentin. They were not tested coming in. They were not tested before they left the prison, and they were put in with general population. This chart that I'm showing here on the right comes from the Office of the Inspector General's report on what happened there. And you can see that in June 1, there's no cases when these people are coming into the prison. But on July 8th, the prison, all the wards are already infected, and there's already thousands of cases in what was then the worst single outbreak in the entire United States. And of course, it ravages death row. It ravages places where there's elderly, infirm people, and many of them die. This just gives you a picture of what's been going on in all the prisons, just to show you that it's not St. Quentin. And you can see that the number of cases per 1,000 people, this is number of cases per 1,000 people, is of course much, much higher in the prison system than it is both in the United States and in California. Just to explain something about mortality rates, as we all know, this is not news to anybody listening to this, mortality rates are of course higher in the 65 plus category, people that are older. However, prison populations, even though we do incarcerate a lot of people over 50, shockingly about a quarter of our prison population is people over 50, we don't incarcerate a ton of people 65 years and older, although we do have a 90-year-old man and a 94-year-old man in California custody. I'm sure they pose a very serious danger to public safety. So when you adjust for age, for the fact that prisoners are a little bit younger than people on the outside, you see, and this is the work of our friends at the UCLA COVID Behind Bars Data Project, that the death rate within prisons, the mortality rate of COVID is at least 3 times what it is in the general population. So how did we try to fight this legally? So this is the legal landscape. Again, probably not new to a lot of you, but I'll go over it quickly. Federally, of course, there's the 8th Amendment prohibition on cruel and unusual punishment. And the standard in the context of prison conditions is deliberate indifference to a prisoner's serious medical needs, which happens when a defendant realizes that a substantial risk of serious harm to a prisoner exists, but then disregards that risk. So it's more than negligence, it's awareness. And of course, we know from what we've just heard that the PLRA limits releases to scenarios where no lesser remedy would do. On the state level, we have our own version of the 8th Amendment in California. It's in Article 1 of the California Constitution. It prohibits curiously cruel or unusual punishment as opposed to and. This little nuance is not unimportant, and I can talk about it in the Q&A. Again, the deliberate indifference standard that is being used on the federal level is good law in California as well. And the context in California is not the kind of class action that we've seen in Plata, but more habeas petitions that people submit in state court asking to be released from custody because of a violation of their Article 1, Section 17 rights. So here's what actually happened. So the same people who were kind of from the people who brought you Brown versus Plata, the same people, the same law firms who brought you that case pursued basically a continuation of it, Plata versus Newsom, at the Northern District of California before Judge John Tiger. Judge Tiger was visibly emotional. I attended all the hearings via Zoom, making emotional pleas to the defendants, please care about the incarcerated people, actually crying with tears on screen. And at some point showing a slideshow of images of the people who died, which included both prisoners and staff. He said during the litigation, my pleas to Governor Newsom to release people have fallen on deaf ears. And nonetheless, he repeated again and again at every status meeting of the case, which is not over yet, still ongoing, I'm not there yet on not finding deliberate indifference. He consistently said that he wanted to have a conciliatory approach. He said, I don't want to give orders. Ironically, orders is exactly what you go to the federal district for, but said, no, I want us all to agree on what to do. And because of this conciliatory approach and the idea of bringing everybody peacefully to the table, he tolerated with fairly good humor a lot of forum evasive maneuvers that were being pursued by the defendants. So the state was making the argument, and this is following the exhaustion argument that Margo just presented, that federal courts are not the appropriate forum. The appropriate forum is to leave this to the prisons because they know what they're doing. Of course, at the same time, and I'm going already foreshadowing what I'm going to say later, the same defendants show up in state court and say, this is not the right forum. The right forum is the federal court. And when they go to the state court of appeals, they say, this is not the right forum. The basic superior court is the forum. So they're playing these forum wars, and everywhere they're getting polite consideration and listening from the judges. Judge Tiger also has this multi-party approach where everybody has a seat at the table. At some point, several months into the pandemic, attorneys representing the CCPOA, which is the union of the prison guards in California, show up to represent the rights of the guards who do not want to get vaccinated and do not want to get scolded for being unmasked and spreading rumors about COVID not existing and about the vaccines killing people. And he consistently flatters them and says, I'm so grateful that they're at the table with us. This is so wonderful. And then the whole conversation turns around, how can we gently and politely persuade the guards to put on their masks and vaccinate? And what did they not do before ruling about the mandate? They said, we're consulting persuasion experts. They went to the Goldman School of Public Policy at Berkeley, reaching out to people who are experts on persuasion, trying to basically crack the riddle of why it is that the guards don't want to get vaccinated. The vaccines themselves were very good news to the court because it allowed them to pivot away from something that they would not consider under the PLRA, which was actually letting people out, to something a lot more modest, which is to ask for vaccines. They would not order the governor to vaccinate, but instead, Tiger actually contacted Governor Newsom and said, can you please spare some, he actually said, couch money to make this happen in the prisons? Finally, after a lot of public pressure from advocates, prisons were prioritized for vaccines, and incarcerated people, much to our delight, took the vaccine at acceptance rates that exceeded the general population. But the guards still would not vaccinate, and to this day will not vaccinate. And so the final ruling in this case that was given just a couple of weeks ago was far more modest than the original scope of the litigation. It was just a vaccine mandate for correctional officers. But that was not okay. And the ruling is now under appeal by the CCPOA and by Governor Newsom, despite the fact that Judge Tiger only ordered the vaccination after the receiver from CDCR himself asked for this ruling. At the same time that this is going on, Several people are filing habeas corpus petitions at the Superior Court of Marin. I'm limiting my story here just to what's going on in San Quentin. One of those petitions is summarily rejected, and immediately the First District Appellate Project takes on the case. It's a case of a man called Von Steich, who is 64 years old and has a lung condition, has a bullet in his lung from a bank robbery from the early 80s. The case shows up at the appellate court after it's been dismissed by the Marin Superior Court, and we have the good luck of showing up before Justice Anthony Klein. Again, CDCR shows up at the hearing and says this is not the forum, there's litigation going on in federal court, and Klein says no, federal courts should be the last line of recourse. What is more natural for somebody than to go to the state court? On the merits, there's a denial of petitioners' claims. That's what the CDCR does, is they say without any factual evidence to the contrary, we're just disagreeing with everything that you say about COVID. And they also say to the judge, there is no need to act hastily. Justice Klein becomes furious and says, yes, there is a need to act hastily. And in October 2020, which arguably is not that hasty, he finds that there's been a constitutional violation of the California Constitution. The remedy is phrased in a very vague way, as it often is in these prison cases for reasons we can talk about in the Q&A, to reduce the San Quentin population to 50% of its design capacity. Basically, to just allow the prison physically to put 6 feet between every 2 people. That's what they needed to do. And that is what doctors recommended in the summer when they visited the prison. Of course, CDCR responds by immediately appealing this decision to the California Supreme Court. And the Supreme Court says, despite the fact that you didn't present any evidence that you've dealt well with COVID, we're going to give you another shot, take it to the Marin Superior Court and show them what you've done at an evidentiary hearing. At the same time, CDCR also says, oh, we can either release people or transfer them. Let's transfer them. Let's transfer them to other prisons. There are lots of problems with this, starting with the fact that California has virtually no rehabilitation programs in any other prison. And Quentin is unusually rich in rehabilitation programs because it's close to the Bay Area and people like me volunteer there, so they don't have to spend a cent on these programs. And because of that, for people trying to make parole that have to take these programs, it's basically telling people you're not going to make parole if you're transferred. And of course, they targeted petitioners later arguing, well, what do you want? You want it out of Quentin. We're taking you out of Quentin. So why are you complaining? The case comes all the way to the Marin Superior Court, where they hold an extensive evidentiary hearing spanning several weeks, including testimony from incarcerated witnesses who are telling us what happened inside San Quentin. And what we learned from these accounts is that the factual landscape is even worse than was exposed in the Inspector General report. First of all, we learned that both UC Berkeley Infectious Diseases and various tech companies offered the prison free help. We're going to test people for you. We're going to fast track the results. We're going to give you masks. We're going to give you everything you need. And the prison said, no, 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 we are fine. There was no serious expert testimony presented by the prison to deny the fact that the conditions were the way that they were. And it transpired that the custodial side didn't even know what the medical side was doing, and vice versa. After many months of this, Judge Howard a few months ago issues a tentative ruling where he says, yes, there's been the California equivalent of an 8th Amendment violation. There has been deliberate indifference, but now we have vaccines, which change the game. So no relief to petitioners. The cases are moot. So what's happening now is that they're now hearing objections to the tentative ruling. This raises the question, is the case really moot? So here's what's going on right now. There's a COVID outbreak at the California Institute of Women involving hundreds of people. The jails, which are bursting at the seams because they're not transferring enough people to the prisons, are seeing numerous serious outbreaks, including in Santa Clara County. And we have 310 active cases in custody. More people dying in the last wave. So here's what I'm thinking. Here's why I think the PLRA is just a scaffold, at least in the case of California. First of all, it's pretty obvious that there's this massive dread or distaste for releases. There's this constant search for low-hanging fruit. We've seen conciliatory and deferent approach toward the state. We've seen an absurd preferences by the justices and judges for consensus in the face of overwhelming evidence of its impossibility. And we've seen a lot of patience for flagrant bad faith litigation, including self-contradictory forum arguments. We've seen a preference for jurisdiction over geography, so a lack of understanding that prisons are actually right near the counties. And if there's an infection in the prison, a few days later, numbers in the county spike. We've seen a lack of understanding that what's going on in prisons also affects what's going on in jails. And we've seen a lot of justice delays, literally denying justice to people because their claims become moot. And there's also an angle of California politics here. This is something that's important for me to explain, and I'll end with that to people from out of state. A lot of these folks that are sort of at the helm of this preventable disaster are widely hailed by everybody as the heroes of the resistance at the national level, right? The people who are fighting Trump, we're the state that's all science forward and vaccine forward and mandating vaccinations in schools. And at the local level, they're behaving at utterly villainous ways. So what are these releases for which we got the C- from the Prison Policy Initiative? This is an op-ed that I wrote the day after Governor Newsom released the prison release plan, which was going to prioritize people who were getting out anyway and were doing short sentences. In November, we got the numbers of who actually got out. The grand total of people that we released out of this 100,000 system was less than 8,000 prisoners, 0.8% of whom were people who were COVID high-risk medical folks. So people, why is this? This is because there's a high percentage of people who are old and have done long sentences. These are the folks that are the least risk to public safety. Rather, they themselves face the most risk because they're old, because they've been in prison for decades, so their health is completely shattered. And they're not a risk on the outside because they've aged out of crime. Nonetheless, because they were sentenced for a violent crime that they did 40 years ago, those are people whose optics of release are the worst, and there's a lot of resistance letting those people out. I can talk more about other aspects of this resistance in the Q&A. And of course, all of these releases are now gone. This is the graph of CDCR population. The trends have now completely reversed. These are the releases of July, and we've now completely eclipsed those, and we have more people than we had at the very beginning of the whole thing. Here's Gavin Newsom, our governor, right? The champion of COVID vaccines, the science forward state, fighting the plans and actually pushing the appeal of the prison guards against the vaccine mandate. Why insist that people vaccinate in schools and protect guards from getting vaccinated? Well, our governor recently faced a recall election and the guards union cut him a 1.75 million check. So that might invite some speculation about why he's so eager to take on their case against the vaccines. Moreover, all of these legal maneuvers that I've shown you are being orchestrated by our Attorney General, Rob Bonta, who was appointed after Javier Becerra, his predecessor, who basically orchestrated this whole disaster, was promoted, of all ironies, to lead the health case in the Biden administration. So here is an image from a protest we did at the San Quentin gates. You can tell this is me at the very beginning, but you can also tell that to my right is Rob Bonta, then an assembly member who was quoted in The Guardian saying, "We're in the middle of a humanitarian crisis that was created and wholly avoidable. We need to act with urgency fueled by compassion." And of course, when he becomes Attorney General, the compassion fades, and we're all going to do whatever we can to not let anybody out. Thank you for listening, and look forward to talking more in the Q&A. This is some of the information for the book.
Wonderful, thank you.
Okay, I am not Professor Hardaway. Something has come up, and so I'm going to step in for purposes of the Q&A. I'm Jonathan Enton, as Andy mentioned before. And I think before we turn to questions, let me ask our panelists if any of you want to respond in any way to the comments of your colleagues.
I have a question I'd love to ask Nancy.
Go for it.
And that is this. I'd actually love to ask Lee this too, but we'll see. Maybe I'll get a chance later. So litigants have been using a habeas avenue into court, a habeas vehicle, to attack conditions that they claim make their confinement illegal, in part because, habeas is habeas, it's the great writ and so on, but in large part because they want out from under the prison release order provisions of the Prison Litigation Reform Act. And I wonder, do you have any worries about, and in the Second Circuit, for example, like habeas is available for that kind of thing, right? Like it's not clear that the prison release order part of the PLRA doesn't apply to it, but it's absolutely clear that habeas is available. So I guess what I wonder is, do you have any concerns about whether using 2241 for that kind of path of litigation would be problematic in some way? Or do you just say, you know, like any port in a storm, sure, go for it?
Well, I think that eventually, if the prediction of the district court that I quoted, that judge was worried, this claim is going to find its way into every conditions of confinement suit. And they're going to be filed under both 2241 and whatever else, you know, the 1983 or Bivens. And it's just going to be a tidal wave of 2241 cases. I think if that happens, we're going to see some pushback.
Right.
But these cases where it's been successful, that is, it's convinced the judge that there's a claim under 2241 and has gotten past exhaustion in habeas and has reached the merits of the Eighth Amendment claim. Those few cases, a handful of them that I could find on, you know, publicly available sources, were cases that were quite narrow, where the class, and some of these are class actions, the class is only the most medically vulnerable people. So it doesn't look like the kind of thing that is going to be a slippery slope that would bother most federal courts in terms of remedy. But so no, I'm not concerned. I'm not concerned.
What prompted the question, and then I'll subside, but what prompted the question was that I've been doing some work on remedies for federal violations of the anti-disability discrimination laws under the Rehabilitation Act. And I found this really interesting case in New York where somebody said, no, there's some case law, it's mixed. There's some case law that says the remedy is an APA suit. It's an Administrative Procedure Act lawsuit rather than a direct action under the Rehab Act. Okay, whatever, that seems stupid, but okay. But I found this one case in New York, which said, yeah, that may be right for everybody else, but in prison, not so much. Bring your disability discrimination claim as a conditions of confinement habeas action. And since you can do that, you can't have an APA case because the APA says only in the absence of another cause of action. And so that began me thinking, I mean, you know, obviously this has a bait and switch quality that's problematic, right? But apart from the bait and switch quality, it's gotten me to thinking about like how would you actually do this if you're not playing bait and switch? What's the right answer? So that was what was prompting my question.
Yeah, that's very interesting. I think we heard about the bait and switch in California as well. You were talking about how the defendants kept arguing, no, we should be over there. No, we should be over there, and out of both sides of their mouths. And that happens a lot with this litigation. All prisoner litigation ends up with that at some point. That's the first reaction that you get from defendants in these cases is, wait a minute, you're using the wrong tool. Let's delay.
Thanks.
Other comments from panelists? We've got a question in the room to facilitate things. Wait for the mic.
I want to let the students go before, I guess.
Well, okay.
I don't know if the camera's on me at all, Nancy and Margo, but it's Lee. Hi, Hadar. We haven't met in person before, just on Twitter, I think. So I guess my response to I have both a question and a response. So I guess I have a question first, which is to Margo. And I have a 6-year-old and a 4-year-old, and people ask me, oh, did you hear this thing that happened in this case last week that's in my area of expertise? And I like freak out because I like actually have been like doing whatever soccer dad stuff nonstop, and I actually don't know about that thing. So like while I'm commenting on the question that you asked to Nancy, I also would ask, did you listen to oral argument in Ramirez v. Collins? And because if you're on our sort of side on this, listening to the justices grill the state about like why it took so long to respond to the grievance form was like balm for the soul. So I guess, Nancy, I wanted to, in light of your answer to Margo, I wanted to ask you, like I'm always ultimately, the lower courts have gotten very frisky on issues where they think they might be able to secure a 5-justice majority to overturn some precedent, right?
Yeah, I like
and-
that, frisky, yeah.
And so, so if you're on my side of this, if you're, very concerned that there aren't procedural vehicles to challenge conditions, I think you're right for most of the jurisdictions, in the sense that I think there's not a slippery slope problem. But and I hate this phrase at this point in my career, but like the circuits are they, not an it. And like the Fifth Circuit certainly would love to get a crack at a ruling in which they could say, no, you can't actually bring this as a habeas claim. And isn't one enough? Because then you have a circuit split, then you go up to a very hostile court, and then aren't you looking at sort of this retrenchment of these really dramatic exclusivity and exhaustion rules that take away the remedies? I just wonder what your thought is about that time.
Well, if you were worried about district courts giving relief that the Supreme Court doesn't really prefer as a reason for them not to give that relief or take that action, we'd be in a whole nother world, right? I mean, there are all sorts of things that district courts are doing that a conservative court would prefer them not to do. But you're asking, I guess, is that enough reason for them not to do it, or to be worried about them doing it in the first place? And I, especially in the context of emergency responses to life or death issues, I would say no. I mean, that's the history of habeas throughout, is that district judges just go out on a limb and do what they think is right to give relief where other courts or precedent might suggest that it's not available, or it certainly isn't present yet, and deal with an emergency, a time-sensitive situation, whether it's the boat lift or military detention, whatever it is, and then maybe we'll get a reaction that says you shouldn't have done that. This is developed into a problem. Something like we saw with 2254, right? I mean, and AEDPA, where Congress and the court both said all these things that you're doing in expanding habeas have created this massive harm and explosion of litigation that we don't need, so we're going to shut it down. That might happen with something like this too, but that doesn't mean that it's not functioning the way it ought to. I mean, my view is that habeas is there for that dialogue. It's for that immediate response and some ultimate resolution over time of what judicial remedies are appropriate for which situations. So I'm not concerned that it might get to the Supreme Court. I hope that eventually all of these 2241 experiments result in some careful thinking on the part of the court and Congress. And I hope that they preserve that freedom for district courts to use their powers and equitable powers under 2241 to experiment. So no, I'm not concerned.
I just to follow up for a touch, you don't even need to respond. I mean, I wasn't sort of pressing as much on whether it was normatively desirable and whether, we think it's inevitable as a predictive matter. And it sounds like we both think it's inevitable that it ends up at the court, and you're a touch more optimistic than I am that maybe the quote unquote dialogue between the lower federal courts and the Supreme Court will result in something a little more textured than prisoner loses.
Yeah, that sounds right.
Other questions? Do we have any questions from the folks who are zoomed in?
Yeah, we do. We have one question from an anonymous attendee, which was posed towards the end of Professor King's segment, which is, what is the Sixth Circuit decision Professor King is referring to?
Williams, Nancy, you're muted.
I'm sorry. It's called Wilson versus Williams, and I'll put the site in the chat. How's that? Again, it wasn't ultimately successful for the petitioners, but it's now somewhat of the leading case, recognizing that there is jurisdiction under 2241 for these no confinement, let me out now claims. So I'll put it in the chat for you.
Other questions? Maybe Professor Aviram, let me ask you one. You focus on the limits of litigation for dealing with conditions of confinement during the pandemic. Sometimes when social scientists talk about the limits of litigation, they talk about either alternatives to litigation or complements to litigation. And I wonder to what extent you might see either alternatives or complements to litigation in this setting.
So I think it's not a big shocker. Thank you for the question. It's an excellent question. I think that it's not a shocker. Excuse me, my research assistant here is getting in the picture. I don't think it's a shocker that we have not been utterly successful in saving people from this disease, obviously, and that's really an understatement. But what successes we've had came not from the governor's mansion or from the courts, but rather from a lot of things that we did in the public sphere that made things happen. The biggest success, I think, that the Stop San Quentin Outbreak Coalition can boast, and this is, I have to say, I've been in the activist space for about 20 years now, and this is the most functional, effective, productive group of individuals I've ever worked with. It's a group of people who were recently released, so they still have a lot of friends inside. Lots of family members of people and other interested parties, lots of healthcare folks, some lawyers, people who bring in a lot of skills to the table and work together in a really admirable and very pragmatic way. So here's what we did that I think was useful. The most pressing thing was to try to figure out which struggle was what we were going to prioritize. And this is where we were having real trouble because people were worried with the advent of the vaccine that everything was going to pivot to the vaccine and the whole release thing was going to go down the wayside, which, as I showed, is exactly what happened in litigation. And I kept saying we can't do this because we've got to save people and we have to have enough love in our heart for two wars. We have to fight the war for the vaccines and the war for the releases at the same time, knowing that we're probably not going to win the war for the releases. We did win the war for the incarcerated people getting vaccinated. And basically the way that we did it was by pushing our own information into the prisons. So at that point, after everything that people have been through, and I can talk some about the evidence that we have from outside, because in the book we feature hundreds of stories from people about all the aspects of going through this hell behind bars, they would not believe anything that CDCR doctors tell them. So, while being told by the guards every day that COVID doesn't exist and that the vaccine is going to kill you, CDCR pushing the opposite message at the same time was ineffective. We had to push in a message that people could 100% trust from a source that they were clear had their welfare in mind. And that source was a group of physicians at UCSF and at Berkeley called AMEND. Those were the folks that visited Quentin in June and made the recommendation to reduce the population. So people knew that they really wanted what was best for them. And they brought in a frequently asked questions piece that we managed to get into the prisons. We also managed to record videos of people who had been just recently incarcerated and still had a lot of folks that knew them on the outside, And they very generously recorded themselves making videos that were about 1.5 minutes saying, listen, here I am getting vaccinated. You should do the same. Like, please save yourselves. Just somebody who was your buddy, who was your cellmate, who has your best interest in mind. And we deliberately kept those short so that they could be watched on a smuggled cell phone behind bars so that people could see them. Later on, both the prisons and the jails actually compiled those. And in some cases, we collaborated with people in the prison and jail administration to put together a video to show folks behind bars. But of course, most of the credit goes to the incarcerated people themselves, right? Managing to inform themselves properly of what was needed for them to save themselves. So I think that of all the things, the most notable success that we had was with the vaccination campaign. At the same time, many of us, including me, but others as well, wrote op-eds trying to get the prioritization of prisons. Now, of course, Governor Newsom boasts that he did this. This was only after very significant public pressure from us. And we could only wish that the same public pressure were applied to the guards and not just to the incarcerated people, because right now, all of the infections that we're seeing popping up again are basically generated by guards bringing it from the inside, from the outside. So this is so I think these are the complementary things that we did. We couldn't, of course, abandon the litigation, and the litigation, as you can see, is still ongoing. But I think that just pushing things in public channels, I think that in the aftermath of the no on the recall, our argument that there is just immense hypocrisy in pushing vaccination in schools and protecting guards from not getting vaccinated has found some purchase in the public. And people were upset about that. So we are seeing some success in that area. But the problem, of course, when you live in a state that's perceived as a blue state, but studying prisons feels anything but a blue state, is that you're a captive audience. I mean, who you're going to vote for? You know, if not Newsom and Bonta, then who? This is who you're left with. So the only thing you have left is to educate and empower people to take care of themselves to the limited extent that they can, and to try to push their case in the court of public opinion.
Professor Kowalski, did you want to make another comment?
So just to switch gears, I guess a tiny bit, and I had 2 questions, and just because of the ordering of the queue, I guess it seems like I'm trying to monopolize it. I'm not. This is primarily for Hadar, but also have Michigan and Tennessee represented here. So you made the comment that, you know, this person featured to the right of you in the picture was going to go on to be AG and forget all about his sympathy and empathy for prisoners. I was really excited when I saw your book project. I actually didn't know about it until just now. I wondered, that was an AG candidate. I wondered if you could talk a little bit in California, and Margo and Nancy, if you know anything about it in your states, about what the behavior of the AGs, the attorney general, the district attorneys in the localities has been like. Has it been a similarly uniform drift, or has it been more, and even has like Boudin been, you know, much more helpful than some of the other people as one might expect? Just, I mean, tell me a little bit about what you're seeing in terms of the political economy of it locally.
So Lee, I am so glad that you asked, because it has not been uniform, because at the municipal level and at the county level, the DAs have actually been very responsive to this. And in fact, I got phone calls from DAs while this was going on to my personal cell phone saying, what can I do to help? I know that I don't have anything to do with Newsom or any of that bunch, like I don't have any purchase at the governor's mansion, but what is it that I can do to help in my county? And what I said was basically, don't just do something, sit there, which is to say, for example, in California, and I'm sure in other places as well, prosecutors show up for parole hearings. I said, can you just not show up? Can you just not be there? Can you just not show up when people have parole hearings? They say, of course, you know, it's not a problem. So in some counties, the DA stopped sending representative to parole hearings. In some places, DA started trying to look for non-carceral solutions to try and save people. Whenever there were cases of elderly people or people that were sick, they tried to look for all kinds of other solutions. We also tried to mobilize the local DAs in the context of what was going on in the local jails. I have a paper out called Bottleneck about how all of this impacted what was going on in the jails, which was its own horror show, because there, as Margo pointed out in a very prescient article about this, we sprouted a Hydra problem, right? We're not dealing with one villain, we're dealing with 58 different villains in different degrees of villainy. And there what you have is sheriffs that are not even reporting the rates of infection or testing. So you don't even have the data to know what's going on, even as you get phone calls from inside saying there's hundreds of people coughing here. So the DAs were instrumental in quietly trying to find solutions for the jail problem, but of course not enough and not uniformly in all counties. And this is where California, which is very polarized, is an interesting case because our blue counties are very, very blue and the DAs were very motivated to help. And in the red counties, there was no help forthcoming and no phone calls came in. So your fate, basically, the extent to which anybody cares about your health and safety really depends on which county you have the good or bad luck to live in. So that's at that level. At the state level, it's just been a horrific disappointment all around. When Bonta was being asked, and this is actually an interesting question to all of you, when Bonta was being asked recently at a press conference, I keep prodding them to ask this, like, how can you support vaccination and at the same time leave this case and shamelessly protect the guards from getting vaccinated? He said, oh, that's a completely different thing. When I'm litigating, I have a client. And I just don't think that this accurately captures what the Attorney General's job is. He's not supposed to be the Tom Hagen of the guards union. Like, he does have some duties to the state and he can't be speaking from two sides of his mouth, which is exactly what he's doing. But I'm going to shut up now because I'm actually curious to hear how this is playing out in other places.
You know, I think that the evidence, jail populations have been down a great deal in the course of the pandemic, but I think the evidence is that that's not mostly been the folks who run those populations, which is a combination of prosecutors and jail authorities. It's not mostly been because they've been releasing people. It's mostly been that you've got kind of stock and flow. The flow in was very significantly slowed for a variety of reasons. Now, I have to say also the flow out was slowed too, right? Because trials got postponed and there hasn't yet been the right kind of analysis to understand, well, how did jail populations go down 20%, 25%, in some places by quite a bit more than that? Was it the flow in, the flow out, or was there some kind of increased compassionate release, et cetera? So I think that by making it a question of the political inclinations of the DAs, you're assuming an answer to that, which is probably not the right answer. I think that the bulk of it has probably been about police processing and what that's done to population. So I slightly resist the question, Lee.
I don't have a lot to add. Tennessee also has the polarization of blue counties and red counties, and you see differences in DA behavior based on that as well. But I do know that law enforcement in state and at the federal level too has been conscious about switching to summonses or non-arrest approaches during the pandemic in ways that they didn't before. So I agree with Margo, it could be DA behavior, but it also could be all sorts of other decision makers that are playing a role in the changing jail populations. I have a question for Margo. Is there a chance to ask that?
Go ahead.
So your proposed congressional response is sort of just the sort of tailored remedy I would expect to come from pressure from habeas cases, and hopefully would be better than the kind that Leah is worried about. But I was wondering if there is a precedent or some experience with the kinds of statutes or emergency grievance procedures that states have used in sexual assault cases. So I know, there are separate streamlined reporting administrative procedures for imminent sexual assault risks in some places, and I was wondering if that might play a role in what you're doing.
Very interesting. So the statutory proposal deals just with access to federal court. It doesn't actually say what should happen administratively. It's just a That's sort of my second proposal, right? The third proposal just says, look, just let people into court. What goes on with respect to sexual assault on that topic has been very, very muddy in the years since the Prisoner Rape Elimination Act, PREA. PREA's regulation, which came out in 2012, says that in order to be PREA compliant, prison systems have to have no time limit on access to a grievance process that's related to sexual assault or sexual abuse. And I think the intent of that regulation was actually to take out exhaustion as an excuse for non-access to federal courts, because the theory was if you file a case in federal court and the judge says, well, you haven't exhausted, well, at that point, you could just go back and exhaust and stay your case and then proceed, right? And so the idea was, let's not tell, there's some other PREA ideas about what that process needs to look like, not so much the grievance process, but the investigatory process. But there's nothing in PREA that governs what the grievance process about sexual abuse, sexual assault needs to look like. What there is just this thing that says no time limits, that's it. And the theory that would give people freer access to the courts over sexual abuse and sexual assault has turned out largely to be a kind of a fail, because the courts have not understood it to mean that. And there's basically been no take up of what was supposed to be this open path into federal court. The one other thing, though, is that the Prison Litigation Reform Act also says that you can't recover for mental or emotional injury in the absence of physical injury. And for a while, courts were saying that coerced sex or rape that didn't include physical trauma, so rape where the physical contact was limited to sex and there were no punches, there was just, rape, right? They were saying, well, that's just mental or emotional, and so you can't recover in federal court for that. And the Congress passed a fix that said, well, if there's penetration, that mental or emotional injury thing doesn't count. Now, just don't even get me started, on, really, you're going to bother doing statutory fix, and what you're going to require is, it kind of boggles the mind, honestly. But that said, those are the two things that have been done statutorily to deal with sexual assault and sexual abuse. And I wouldn't say that either of them is very satisfactory.
So the lessons from that are useful as what not to do.
Yes, that you are clearly the optimist among the three of us, but yes, correct.
Okay, thanks.
Other questions, either online or in the room? Let me take the moderator's prerogative one more time. Professor Schlanger, to what extent do people thinking about exhaustion in the PLRA and habeas context generally think about exhaustion by analogy to administrative law? You noted that there are provisions suggesting that the sort of traditional administrative law type exceptions like futility don't apply. At the same time, the Supreme Court has been saying that the common law, administrative law doctrines of exhaustion of administrative remedies don't really apply unless Congress has specifically legislated. And I'm wondering to what extent that might inform the way we think about exhaustion in the prison context.
Right, really interesting question. So, there's no provision in the PLRA that says, hey, by the way, this is not administrative exhaustion the way that it is under the APA. That's actually entirely interpretive law coming from the Supreme Court. And I recall a brief that I wrote working very hard to say, futility. And by the way, isn't this kind of exhaustion simply a ripeness rule, not procedural bar? Because when we talk about exhaustion in the habeas context, sometimes we mean ripeness, not procedural bar. And so isn't this a ripeness, not a procedural bar? All right, Nancy, it was a little bit of a stretch possibly, but I thought it was not crazy. And the court, I did have this one very proud moment where Justice Breyer asked a question waving around my brief saying, isn't it like this? But I didn't get almost any traction. And the court has been really clear, like this is not administrative law. This is Congress intended this, they say. I don't actually think you can really tell much about what Congress intended in the PLRA. It has a very minimal, it's got very, very few words, and it's got a very minimal legislative history. And most of the legislative history is actually about the injunctive parts of the statute, not about the parts that govern damage actions. So I don't know how you know what Congress intended, except that they intended to put the kibosh on prisoner cases. And so if you think, well, that's what they meant to do, well, yeah, then it's got to be a procedural bar. And so that's pretty much what they've said. So I think that the Supreme Court has fairly definitively rejected the idea of the sort of cross-fertilization that you're talking about. That said, you know, it's a very textualist court right now. And that has led to what is, you know, been a fairly positive change in jurisprudence along the PLRA. The courts of appeals were split about this idea of availability as a limit to the exhaustion requirement. And the Supreme Court, you know, read it and said, well, but it says it has to be available. And so, no, we're not going to do futility, and we're not going to do ripeness, and we're not going to do latches, and we're not going to do, I don't know, you name it, like whatever you want is either equitable or administrative law principles. We're not doing any of those, but it says availability right here. That's the one we're going to do. So I would say that the ad law case law that you're talking about is of a piece with Ross versus Blake, which has been the only kind of positive change in the jurisprudence of exhaustion since the statute was written in 1996.
Okay. In order to keep us on time, even though that was a really dry technical point, I apologize closing on that. But I think to keep us on time, we should thank our panelists for a really terrific discussion.
Thank you.
We'll reconvene at 10:30 in 15 minutes from now, and look forward to the next session.
Yeah.